Hi again, everyone, and welcome to Legal Spirits, the podcast of the Mattone Center for Law and Religion at St. John's University. I'm Mark Movsesian, the center's director. In today's episode, we're exploring a new law out of Washington state that's raising major constitutional questions. The law requires clergy to report suspected child abuse, even if they learn about it through a confidential spiritual communication, like the sacrament of confession in the Catholic Church. Now, that's unusual. Most states that require clergy to report abuse still protect the traditional clergy-penitent privilege. But Washington has removed that protection, while preserving other privileges, for example, the attorney-client privilege. Does that violate the Free Exercise Clause? What does the Constitution say about compelling clergy to break spiritual confidences? And how has the clergy-penitent privilege evolved over time? In this episode, we'll look at the constitutional framework, the history behind these debates, including a remarkable early case from 1813, and the broader issue of why the law protects certain confidential relationships at all. Now, joining me to unpack all this is my colleague and friend, Marc DeGirolami, the St. John Henry Newman Professor of Law and co-director of the Center for Law and the Human Person at Catholic University of America. And also, listeners will remember, the former co-director of the Mattone Center at St. John's and the co-host of Legal Spirits. Well, Mark, let me just say welcome back to the podcast. It's great to have you with us again. It's been a while, Mark, so please catch us up. What's been going on all this time?
Well, thank you so much, Mark. I'm always just delighted to be back here. Back for a little moment to the way that it was, and with all of the wonderful things that we were able to accomplish together. You know how much I miss you, and I just love being here. Yeah, so we've been active at Catholic University. We've got our center that I co-direct with my colleague, Professor Elizabeth Kirk, the Center for Law and the Human Person that you mentioned. We had a wonderful conference this past spring on the question of knowledge and institutions, and we had a number of very interesting talks and speakers. And we're doing our own podcast, a separate podcast, a junior podcast to this very esteemed, august, older podcast. Ours is called Sub Deo et Lege, under God and Law, that I do together with Professor Kevin Walsh, my new regular podcast partner. But it's wonderful, as I say, to be back here with my older podcast partner.
Well, Mark, maybe let's say former podcast partner, but I'm delighted to have you back again. It's so great to have you here. Well, let's begin with the Washington state law itself. So, Mark, what exactly does Washington's new statute require of clergy?
Well, as you summarized in introducing the podcast, Washington has added clergy to the list of mandatory reporters, people like doctors and teachers and psychologists. And so now clergy are required to report suspected child abuse or neglect when they have reasonable cause to think that it has happened. And they have to do so within a certain time frame, 48 hours. But what makes this law, a couple of things that make this law, I think, different than laws in other states, even those that require clergy as a general matter to report child abuse, is that the law requires reporting even if the information comes from a confidential spiritual communication, prototypically like, as we'll discuss, confession. And I think, for my money, what makes this really unusual, the statute especially unusual, is that it expressly retains all other professional privileges, like the attorney-client privilege or the psychotherapist-patient privilege and various others, but not the so-called clergy-penitent privilege.
Right, Mark. So lawyers still get to keep their clients' secrets in these situations, but clergy don't. Is that right?
Yeah, that's right. That's right. And right. So the statute says this, it carves out this exception, quote, except for members of the clergy, no one shall be required to report when the information is obtained solely through a privileged communication. So we'll talk about it a little bit, but that carve out, that targeting in that way is probably going to be constitutionally problematic.
Right. Now we should note that under the statute, certain lawyers do have a duty to report suspected child abuse. So, for example, attorneys who serve as court-appointed legal guardians, they would have to report child abuse. But generally, under the statute, attorney communications remain privileged, and as we've said, other professional privileges are not affected. Okay, Mark. So let's turn to the constitutional issue. It seems to me, anyway, that the statute is pretty clearly unconstitutional under current free exercise doctrine. I think you agree with that.
Um, yes, but it will depend on which theory of free exercise we go with. I think the statute is pretty clearly unconstitutional on some theories, but not necessarily on other theories. So, look, if you look at current Supreme Court free exercise law, if a law singles out religious exercise for disfavored treatment, or if it provides exemptions for secular conduct while denying them for analogous religious conduct, it's got to survive strict scrutiny, which means, and your listeners will be familiar with this, that the state is going to have to show a compelling interest and use the least restrictive means to achieve that interest, and that's pretty tough to show as a general matter. So in this case, Washington allows secular privileges like the attorney-client. Well, let's take a step back, I guess. So, Washington, the fact of including clergy in the same kinds of reporting requirements as everybody else, I don't think is the singling out of religion. It's simply the including of religion or clergy with respect to uh, this reporting requirement that all other or a number of other professionals are subject to. So that I don't think is a targeting issue. But here, um, it's the privilege issue, the privilege component that I think is the tricky part. So it allows secular privileges like the attorney-client privilege, but it denies the religious equivalent. And under Fulton versus City of Philadelphia and what some scholars call the most favored nation principle of free exercise, that's a problem. That's the kind of discriminatory structure in a law that the court isn't going to look on favorably.
Right. So the argument would be if the state thinks that deterring child abuse and punishing child abuse is a compelling interest, and of course, what could be a more compelling interest? The question would be, well, then why do you allow any privileges at all?
That's right. And I think especially under the so-called general applicability prong of these, or how to say, theory of free exercise, if you let lawyers withhold the evidence, or if you let psychotherapists withhold the evidence, why aren't you letting clergy, in the context of a confessional, withhold the evidence? Either, if it's really the interest is really compelling, either you want all the evidence, or you're making some kind of judgment about which relationships deserve legal protection. And arguably, that's where religious discrimination comes in. But it's also a suggestion that your interest really isn't as compelling as you're saying it is, because if it were, you'd make no exceptions to it.
Right. Now, you said there's some other theories that maybe don't really hold up here. Now, there's one line of cases in which the court has said that if the state disparages someone's religious convictions or expresses hostility, that's kind of a per se violation. Or if the state compels you to say something that is opposed to your religious convictions, that's also a per se violation. But you and I were discussing this actually, and it doesn't really seem, at least as far as we know, we haven't seen all the record in the case, doesn't seem like those are really at issue here.
I think that's probably right. But again, you're quite right. We don't know all of the legislative record and what people said. But, I think you pointed out, Mark, that there was some material in the record that suggests that somebody said something like, well, the Catholic Church is constantly changing its view about these sorts of things, about what's part of the confessional and what's not. So what the hell? We might as well make this law and sort of see how it falls out. Something like this.
Yeah. Well, so the bill's sponsor is recorded to have said something like, "Look, canon law changes, and I think canon law should change here." Well, in Fulton versus City of Philadelphia, there was a city official who said, "Why don't you get with the views of Pope Francis to the Catholic Adoption Agency?" but the court didn't go down that path in Fulton.
Correct,
And
correct.
right,
As it did in Masterpiece Cake Shop, right? In
yeah,
Masterpiece Cake Shop, you had really strong denigration or disparagement of the baker's religious beliefs, and I, for the moment at least, I don't see that kind of evidence or a parallel kind of evidence in this record. But who knows?
yeah,
It might show up.
yeah, and also in one of the COVID cases, the case from Brooklyn, there was some suggestion that the city officials had made disparaging comments about certain religious groups, and again, the court didn't want to go down that path. So, and I don't think the court would have to go down that path here because of what we said. This doesn't seem like a generally applicable law. It seems like there are other exceptions, and so why can't there be an exception here? Okay, Mark, let's step back a little bit because this issue isn't new. In fact, the clergy-penitent privilege has been debated in U.S. law for more than 200 years. One of the earliest free exercise cases is a case called People versus Phillips from 1813, and it dealt with this topic. Now, Phillips is not a free exercise clause case. It was decided under the New York State Constitution because the free exercise clause didn't apply to the states at the time. It's not exactly the same issue. Phillips involved a criminal trial, testimony about stolen goods. This is, of course, a different sort of thing. But to my mind, the legal principles really are much the same. So what happened in the case? A Catholic priest in New York refused to testify in a criminal trial as to the identity of someone who had returned stolen goods during confession. And the state argued in the case that the priest had a civic duty to cooperate with the trial and testify as to who the culprit was, and that religion was no excuse. Public safety was at stake, the state said. Nonetheless, the court in the case, and I should say the judge was DeWitt Clinton, who's a famous New York politician, opened the Erie Canal. He was acting as a judge in the case. The court ruled in favor of the priest, saying that the state couldn't force the priest to violate the seal of confession. That, the court said, would interfere with one of the central ordinances, quote unquote, one of the central ordinances of his faith, and require him to choose between a religious obligation and a civil obligation, which the court said would be a terrible choice to have to make.
Yeah, and I just want to point out, Mark, that line about the central ordinances, contravening the central ordinances, I think that's important, right? Because it's, anyways, we'll talk a little bit about it, but it's pointing to something limiting with respect to the scope of this particular privilege. Anyways, keep going.
Yeah, very good. We will talk about that. Now, as to the public safety argument, remember the state said, look, we have a public safety interest here. You've got to cooperate with a criminal trial so that we can, find out who the culprit is and as I say, restore public order. The court said that the privilege didn't really interfere, the clergy-penitent privilege didn't really interfere with public safety, and in fact might even promote public safety by causing people to come clean and confess their crimes, as had apparently happened in the Phillips case itself. Plus, the court noted that New York State already respected the attorney-client privilege. So obviously the implication is, well, why not protect the priest-penitent privilege as well? So to me, Mark, it's striking how little the arguments have changed in 200 years. We're still debating much the same issues: public safety versus religious freedom, protecting the ordinances of a faith, whether believers should have to choose between civil obligations and faith obligations, and also the need for equal treatment between religious considerations and secular considerations. But Mark, you've said now a couple of times, you've hinted at this, and I know because you and I were talking before we started to record, you think that there's a broader question that we need to address here, and that is, why do we have privileges like this in the law at all?
Yeah, I do think so, Mark. And I sort of put my cards on the table. I don't like privileges, generally speaking, right? I think that, or if I do like them, I feel very qualified about them. So we need to ask, why do we have them? So privileges like attorney-client or spousal or clergy-penitent or psychotherapist-patient and so on, they are exceptions to the general rule that courts and juries get access to all relevant evidence. So privileges, their function is to obstruct getting at the truth, getting at accuracy. So if we're going to allow these privileges, we need a pretty good reason. to allow them, and we do allow them when we allow them because we think that the relationship that we're protecting is so important that it justifies suppressing the truth. And so, for just an example, for lawyers, the rationale is for the attorney-client privilege. Like, if clients can't speak freely to lawyers, then the entire relationship kind of collapses. We actually can't have representation unless clients. It's not just that clients will feel inhibited; it's that we can't actually enjoy this relationship, the attorney-client relationship, in the way that we've envisioned it without this privilege. Same thing, kind of thing for spouses, right? Intimacy, trust require confidentiality. If spouses can't rely on that trust, on that, we could say, fiduciary obligation to one another, then we just can't have marriage. So, for me, at least, with clergy, or what has come to be known as the spiritual privilege, the justification has become a lot less clear than it was in a case like Phillips. Is it religious freedom? Is it psychological privacy? Is it the theology of the particular set of beliefs that requires the privilege, such that if we don't have it, the religion is going to sort of break down? I think over time we've lost track, and there are a number of these that are sort of circulating. And one thing that we haven't talked about actually yet is that I think because of the confusion in the justification for this privilege and the expansion of the privilege over time, you're seeing many more states starting to encroach on the privilege, starting either to reject this privilege or to really, really limit it in a number of ways. That is a new phenomenon by comparison to what was happening in the 20th century.
Well, look, in Phillips, it's pretty clear. If you say, what's the justification for the privilege? In Phillips, it's pretty clear that the justification is protecting the ordinances of a religion. That's that word again, ordinances, and also protecting individual religious conscience from having to make a choice between faith commitments and civic commitments. But I gather from what you're saying that you think this is sort of a new thing and that the privilege has been expanding over time.
Yeah, I think that's true. So the first thing I'd say is that at English common law, and again, I'm not a legal historian, so this is on the basis of things that I've read about the privilege. But at common law, the so-called sacerdotal privilege, right, the privilege for priests, didn't exist. There's some evidence that maybe English courts were reluctant to compel priests to give testimony, to break the seal of confession, but there was no categorical privilege. In the early United States, in decisions like Phillips that you're talking about, the privilege was very narrow. It was almost like a counter common law sort of privilege, and it protected formal confessions of sin made to ordained clergy, but only in traditions, theological traditions, where confessions were required. So Catholic priests or certain Protestant ministers following denominational discipline.
Yeah, only some, actually, only
Only
some
some.
Protestants. Yeah.
Only some, right? And so it was a very and from what I understand, this privilege was developed for these particular groups because it was thought that principles of religious freedom required this kind of protection in order to allow Catholics to stand on equal footing with other citizens, that otherwise they would be discriminated against. But it was because of the theological component that was determined. But
Yeah.
in the mid 20th century, this privilege, together with the definition of religion at law, expanded greatly. And today, I think that culminated in sort of the 1970s, right, with a huge expansion of the privilege contemplated by Congress in the federal rules of evidence. And so today, it can cover any spiritual communication with anybody performing religious functions, even in informal, unstructured settings. And so courts call this the spiritual privilege, which is completely disconnected from any specific theological requirement.
Well, you can see why that would happen because it's a matter of state religious neutrality. Once you say that certain groups can get this because of their theology, then that's open to an objection. Well, how come we can't too, right? And, you can see why that would happen. But but over time, you're right, it becomes less tied to a specific sacramental practice, and I guess you think that's a problem.
Well, there was a wonderful old piece by our friend Professor Philip Hamburger at Columbia, and the title of the piece is "More is Less." More is less, and I think that that is a perfect description of what's happened, not only with respect to the privilege, but with respect to the definition of religion, free speech. There's a sense in which you stretch out these rules to become more accommodating, more pluralistic, and so on, and they lose the justification and the kind of center or core about what they were really about. And I think that's what's happened with this privilege. It's why it explains in some ways why many of these states are saying enough, right? We can't have a privilege that has this breadth, because privileges, as I said before, privileges are problematic, right? Privileges don't come without cost. There's a big cost in privileges, and they become harder to defend when those privileges sort of start encroaching into territory that conflict with or run up against compelling state interests, like preventing child abuse.
Yeah, so then, Mark, would the idea be, would your argument be, well, I guess you could say, let's just get rid of this, or maybe you define it more narrowly. Maybe you go back to what the original understanding was. By the way, you said it wasn't a common law privilege. I just want to point out for our listeners, it is routinely described as a common law privilege. So maybe that has just an error that's crept into the literature. But would you then argue we should define this more narrowly?
Yeah, it's a tricky question, I think, at this point, because defining it more narrowly might conflict, Mark, with some of the other principles of religious freedom that are now entrenched, right? So now sort of do another podcast about whether those principles themselves are problematic, right? Whether the definition of religion under in American law has created some of these problems. I know a person on this podcast who's written about these questions, and I'm looking at him right now.
Yeah, that's me. That you can't look at him, listeners, but that's me he's talking about.
So look, I mean, I think yes, I think that in order to give the privilege adequate justification, it ought to be, and I should also say, in order to restore its traditional function in American law, a function that was sort of wildly went askew or went wild in the mid to late 20th century. I do think that some kind of restraint on the privilege, or some kind of narrowing or better definition of the privilege, is necessary, just so that we don't lose the privilege entirely. Because I think that, as you've pointed out, in something that I read of yours, the trajectory seems to be in the direction of states dumping the privilege altogether. This is not the first time that this has happened, I think, in Washington. There are other states
Yeah,
that
there are. So there are a number of states that require clergy to report suspected child abuse, but most of those states say that the reporting requirement doesn't extend to confidential spiritual communications. Like if the clergy finds out some other way, you have to report it. There are a handful of states, though, that say that no, the clergy, like Washington State now, a handful that say actually no, the clergy has to report what the clergy learns. Even in the context of spiritual communications, confessions. And that does seem to be a trend that's happening now. More states are doing this. Well, Mark, I'd like to reflect a bit about the recurring nature of this debate. I want to step back a little because I think it tells us that the tension between religious commitment and public policy is a perennial one. It comes up in this context, it comes up in a lot of other contexts. Um, these are hard problems. And as you say, religious exemptions always come with costs. Sometimes we as a society decide the costs are worth bearing. To my mind, what this particular example shows us, this recurring example going back 200 years at least, is that the challenge is always knowing where to draw the line. When you say that a faith practice is so fundamental that forcing someone to violate it is just too high a price to pay for any public good. That, it seems to me, is the lesson of this example. It's a recurring problem, and over again, we have to ask ourselves that question. What do you think about that observation?
I mean, look, I think I agree with it, and I also think that there's another line drawing problem, And that's the line drawing problem of where does a right or a privilege, right? These are sometimes referred to, right? We talk about the privileges or immunities clause, which we sometimes say is synonymous with the rights clauses, right? Where do rights end? What is the limit of rights, which is something like the inverse? And how do we draw the boundaries of rights so that they don't kind of take on a life of their own and hyperinflate so that they inevitably will run into the kind of compelling common interest that perhaps in centuries past they didn't, because the right or the privilege was constructed more narrowly. So I think it's for me, it's the usual problem of pluralism, right? Rights are inflated to account for pluralism, and that's a laudable move. That's a laudable impulse in many respects, but it comes with problems because as those rights get larger and larger, they're more and more likely to come into conflict with things that a lot of people care about.
Yeah, I would say I agree with you, and I would say it a little differently because things like rights, it's like Hofeldian problem, things like rights, privileges, these are just labels we put on things. What we're really deciding here in these cases is, how much is the minority to be accommodated? And what can, or another way to think about it is, what can a religious minority reasonably expect in the way of accommodation from the majority? That's ultimately what we're asking here. Sometimes we think the minority can legitimately ask for quite a bit of accommodation, and sometimes not. But calling it right or privilege, it's essentially that question, it seems to me, Mark.
A wise and wonderful colleague of mine, former colleague of mine, always used to say in advance of our joint law and religion seminars that is always the key question: what can the minority reasonably expect of the majority? And listening, coming onto this podcast, it just occurs to me, Mark, how right you have always been about this critical point.
Well, thank you, Mark. That's kind of you to say, and I think we'll give you the last word. That's how I'll end it. So, Mark, thank you again for joining us on Legal Spirits. Don't be a stranger. You know the way. It's always fun to have you. I'm sorry we haven't had you for a while, but it's great to have you back, and I hope we'll do it more frequently. And thank you to our listeners. For more on this topic, please do check out the Mattone Center's YouTube channel, where we have a new video series, Landmark Cases in Religious Freedom. And one of the episodes discusses People versus Phillips. It's the first one, in fact. So please do check out that video if you'd like to learn more about that case. And for Legal Spirits, you can find us on Apple iTunes, Spotify, and other streaming platforms, as well as on the new YouTube channel. Please like and subscribe, as they say, and stay tuned for future episodes. But that's it for now. See you next time.